Tran. I have the honor here of presenting to you about the implications of the America Invents Acts. With us is Mark Reyland, and he's the Executive Director for the United Inventors Association, one of the largest associations of inventors there is.
Hi, my name is Mark Reyland. I'm the Executive Director of the United Inventors Association of America. For those of you who don't know what the UIA is, we're the largest inventor organization in the country. We were started about 27 years ago by the U.S. Patent and Trademark Office to help inventors understand the educational and commercialization processes of taking products to market. Obviously, as a national organization for the industry, we're very interested in the effects of AIA on the individual inventors. So we've been very active with the PTO over the last several years as the bill has gone through its passage. Tran and his company Tran and Associates, who is a patent firm out of San Francisco, is a very active member of the UIA, very actively involved in helping the UIA understand these issues, and was a very strategic partner with us in developing a tool that we think is important for the inventors to have access to in responding to the changes of the American Invents Act. Val can explain those.
Yes, the major changes to the AIA, we can summarize it up into three major sections. We have what is called first inventor to file. And this creates a race to the patent office for filing purposes. And so the implications of this new rule is to accelerate the patent filing process. Patent applications are going to be segregated according to the March 16, 2000 deadline. So cases prior to March 16 will be accorded the traditional the date when you actually conceive of the invention, whereas cases after March 16, 2013, it will be whoever wins the race to the patent office. So one implication of this is we recommend is that prior to March, the inventors should file all their applications, and thereby get the benefit of the old system in advance. So the second implication of this race to the patent office for filing is that interferences will be eliminated. So interferences are proceedings in which the inventors show to the patent office that they have they were the earlier inventor. They first conceive of the invention, and then they diligently worked on experimentation, and then finally they file the case. As long as they can chain that with diligence, they can get move their invention date from the filing date all the way back up to when they first came up with the concept. Now, of course, with the new system, that's the race to the patent office, interferences will no longer be needed. There is a wrinkle that the AIA has added to this, which is called post-grant opposition. So that procedure allows inventors to examine recently issued patents, and then you can challenge those patents if you think that the inventor of the patent actually derived the idea from you. So the implication of this is that you are going to have to monitor newly issued patents in the space that you invent in. This adds an extra layer of work. However, this will be very useful because I think you should do this independent of the requirement, because you should know what your competition is doing. So in general, I think that's a good thing to do at any rate. So next, we're going to walk through the traditional way of determining the date of inventorship. So in this example, let's say inventor A conceived of the invention first. So and subsequent to inventor A, you have inventor B who invents behind inventor A, but at some point file a patent application ahead of Inventor A. So now in our existing system, Inventor A conceives first, and then he can spend time exploring commercialization possibilities. For example, he'll search the prior art, he'll do his market analysis, and then she can go to perhaps the potential customers to see if there's any interest in the invention. And then assuming that the answer is positive to the search and the market analysis, the inventor can hire an attorney to draft and file a patent application. And this may take some time, but as long as that is coupled to due diligence, due diligence in doing this, i.e., you continuously work toward the next objective, whenever you file, that filing date may be a long time from the date of the conception, but as long as you have diligence, you can chain it back. So after you file, the application will go through the normal U.S. Patent Office procedure in examining the case. And the use of the notebook in the old way is you can chain your invention activities and your commercialization and your reduction to practice, and you can chain your filing date all the way back to your conception date. And so as the graphic indicates, the lag between conception and filing can be very long, a few years, but you can still get that time back if you show that you are diligent and if you have enough proof proof of diligence. So in that case, Inventor A wins. So this is the system that exists now up until March of 2013. So now let's switch into March what happens on March 2013. So you will still have the same activity where the Inventor A invents, however, Inventor B in this case invents and file it faster, and because the new system grants the filing date, as of the filing date, Inventor B will file regardless of, when.
2 years ago. And because we knew as AIA passed, and at that point it was very evident that the law was going to pass, that an inventor could lose their rights because they went to their patent attorney in Florida and said, hey, will you file this provisional? And the patent attorney said, oh, sure, no problem. I'm going on vacation next week. I'll do it right when I get back. And while the patent attorney is on vacation, a guy in Oregon comes up with the same idea. Unbeknownst to the person in Florida, the person in Oregon is going through the same process. The only difference is his patent attorney didn't go on vacation. So we needed to take a look at the impact of pro se filing, which is filing by yourself without the use of a patent attorney, and the increase in pro se that was going to occur naturally because of this law, and look at tools. There are several books out there, there are several tools out there that help inventors, author PPAs. We really wanted to make sure that there was at least one really good tool out there that did it well and gave you the ability as an inventor to file this PPA in a very timely manner, and was designed in such a way that it encouraged you to do exactly what Bao is telling you to do, which is don't just do a quick PPA sketch, which is what a lot of people think a PPA is for. They think, oh, if I just get my basic idea down there, I can file the PPA and I'm safe. But that's not true. That's not the way it works. You can't represent in a converted utility patent what you didn't represent in your PPA. And so it was really important to the community to make sure that a tool like this was developed so that when the average inventor was using it, what they were producing was a good PPA that could then go on and help them enjoy longer-term protection.
Great. Well, thanks. We'll show you some the tool, and some of the few people who've used it, they've generated amazing results. I had one beta user who tried this, and he has never seen a patent before, and he wrote something that just blew me away. But we'll get to that later. But first, let me take this opportunity to introduce Dr. Phi Nguyen. He's a surgeon and a co-founder and founder of MIBA Medical Inc. And let me let pass the phone to him, and he can speak a little bit about how his startup, Silicon Valley startup company, deals with the effects of the new law. Phi?
Hi everyone. Hope you can hear me. I'm Phi Nguyen, and I had the pleasure of using the Power Patent software to help jumpstart my startup company here. We're just a small medical device company in the dermal filler space, and while I was inventing this, it came upon me that I really needed to make sure that my ideas and inventions are protected with patents. I tried to find what's the easiest and most cost-effective way for me to go about it, and this seems to be the right solution for my company. It was easy for me to just type in the subject matter that I was interested in, and to see a list of similar patents and things out there without me having to do or knowing how to do a full search of the space. And I was quickly able to see what was out there to show that my invention was actually unique and that I should go ahead and protect it with patents. And it also allowed me to see some of the sample patent in the similar space to kind of aid me in how to write my patent itself. Since I've never written any of this before, all this was new to me, so this was quite helpful to see a previous patent and the style it was written in for me to write mine. It also helped a lot to see that I wasn't encroaching on anyone else's space, and that mine was actually unique, and it helped me to quickly write one and file for a provisional patent. So that was my, it was very cost effective for me as a startup company to use this also, because we did a lot of work that usually you would have to hire a patent attorney to do, and now by the time you are ready to speak to a patent attorney, you have pretty much a lot of the legwork already done, already saving you quite a bit of money on that end, and time also. So I know Bao and the folks there have some sample coming up to show you how the workflow goes and how easy it is to use the Power patent, but just wanted to speak to you briefly regarding my experience and how I use this to jumpstart my business. Thank you.
Well, great. Well, thank you, Phi. So we have some slides that shows this, but I think the most fun is actually let's see it live in operation. So I am going